Good evening, everyone, and good morning, the participants who are like Professor EUGENE FIDELL. I, on behalf of Beyond Law CLC and ULS Punjab University Chandigarh, welcome you all to another webinar on it, as we have promised that we try to engage everyone on different issues which are correlated with the society at large, and we always bring topics wherein persons with different interests join, and some people in fact are joining for all the webinars so that they can have a main bird-eye view of all the issues. Like today we have global military reforms and military litigation in India. As we all know that during this lockdown period, yes, it had been at the first instance a different perspective that we were all locked down at our homes. One way was just keep on watching movies on the Netflix, etc., etc. Another way was to enhance the knowledge in a different way. One was through the YouTube channels, or other was like we all did, that let's go for webinars and ask the experts the different points, different perspective on different issues, so that if anybody had certain issues within their mind, or if at all they did not know anything, they could get enlightened from the experts. Amongst us today, we have Professor EUGENE FIDELL, who teaches at the prestigious Yale Law School. He's the President Emeritus of US National Institute of Military Justice. He's an author of repute, editor of blog Global Military Justice Reforms, former JAG officer of the US Coast Guard. Then we have AISHWARYA BHATTI, Senior Advocate, Supreme Court of India, who has been twice elected as the Secretary of the Supreme Court Bar Association. Presently, she is an Additional Advocate General for State of UP in Supreme Court. She has been the Counsel of Delhi High Court and Supreme Court, and she has represented issues which are of larger interest of the society at large. She has contributed in the legal fraternity, which also, in fact, also has effect on larger issues of the society at large. She was the counsel in the right to privacy, tribunalization, the judgment of Roger Matthew, etc. Then we have amongst us Major NAVDEEP Singh, an advocate of Punjab and Haryana High Court, the place where I am also practicing. He is the founder president of Armed Forces Tribunal Bar Association in Chandigarh. He has authored various books and he has written various articles which in his own way help to understand the military law and the issues of the military. Keeping in view his immense knowledge, he was made part of the high-level committee of experts of the Military of Defense to reduce litigation initiated by MOD. All three persons who are here have contributed a lot towards the global military reforms and military litigation in India. We thought that why not bring the experts and have the views of the persons who have contributed immensely in resolving the issues, especially in respect of military litigation in India, and their write-ups, etc. They can have helped us to think in a different way, the reforms, etc. Invariably, we have all been holding webinars wherein the keynote speaker comes, he pitches in his own views in terms of the legal insights, etc. And then we have a question answer session. We thought that we should take this time on a different pedestal. We will just ask certain questions, and then anybody can post their questions on the group chat so that the questions and their resolutions to those can be had from any of the three persons who have their immense knowledge to contribute in their own way. First, I will ask Professor EUGENE FIDELL as to, could you just explain the basic difference between the system of military justice and regular criminal justice? More so since you have authored a book a very short introduction of military justice by the Oxford Press. Professor EUGENE FIDELL.
Right. Good evening, everybody, or good morning, depending on your time zone. The starting point of the answer to your question is that military justice vindicates an additional interest beyond simply the achievement of justice that any system of criminal law seeks to achieve. That second interest has to do with ensuring discipline within the military, so that any court-martial is supposed to not only do justice in conventional criminal law terms, but also to make sure that discipline is achieved. And why is discipline important? Because discipline is important to mission accomplishment. So that's the starting point. Now, historically, of course, the military justice system sprang from different roots, and this varies from country to country, obviously, but just thinking about the American system, which is vastly and needlessly complicated, the military justice system actually predates our Constitution. And so certain aspects of the military justice system have traditionally, and until this day, not tracked with the requirements that the Constitution imposes either on our federal courts or our state court systems. All of our states are sovereign, we say, and all of them have their own court systems, which are an imperfect mirror of the requirements of the Constitution for federal courts. So that, for example, in our antique Constitution, you can't be tried in a federal court for a felony unless you've been indicted by a grand jury of 23 people. That requirement doesn't apply to the states, and it certainly doesn't apply to the military justice system. There's an issue of whether a jury has to be unanimous. This is a really recent issue. Jury unanimity is not provided for in so many words in the Constitution, but the constitutional provision has been interpreted from the beginning that a trial jury in the federal courts had to be unanimous, and had to be 12 people, by the way. That neither of those requirements until recently, let me be a little more precise here. Until very recently, the jury unanimity provision was not believed to apply to the states unless the states happen to adopt jury unanimity. And 49, I think 48 and then 49 states have moved in that direction. But under a very recent US Supreme Court case, jury unanimity is now required. In contrast, except for capital cases, jury unanimity is not required in a court-martial. So those are major differences. In fact, you could be convicted in a court-martial consisting of as few as 4 people, and possibly 3. And Dwight can correct me. In some circumstances, you could have it down to 3. So there are major differences. On the other hand, there are also plenty of similarities, and these include the rules of evidence. The rules of evidence as between civilian federal courts and courts martial are the same. There's a judge. The judge has a law degree, typically wears robes. There are lawyers in every case, basically, on both sides. The judge instructs on the law, does not deliberate with the members of the court-martial panel. So in many, many respects, particularly over the last 50 years, the military justice system has assimilated more and more towards the civilian model. We don't have in this country what is known as a compliance system. I'm using the Strasbourg term. Neither, I believe, no offense, I don't believe the Indian system is compliant either. And we can maybe get into that. Why don't I stop there, because I don't want to monopolize the conversation. I'm very anxious to hear what other people have to say, and I'm also particularly anxious to respond to any questions and stir things up a little bit.
So, could you please tell us the latest trends in the global military justice reforms process, according to you?
Say that one more time, please. I'm sorry.
So, could you please tell us the latest trends on the global reforms justice, according to you?
Right. Well, I think what you're seeing is a continuing trend. Again, we're talking about broad sweep. You're seeing a continuing trend towards the integration of military justice into the larger system. I think increasingly countries are recognizing that there's got to be appellate review by the country's highest court. I think there actually is a trend in a number of countries towards getting rid of their military justice system. I personally don't advocate that, but you can certainly find countries that have moved in that direction one way or another. I mean, every country has its own, for political and traditional reasons, way of reconciling that. I think a major issue has to do with the role of the role of commanders in the administration of military justice. And I think a major trend is increasing interest, and I know Navdeep Singh has been very engaged in this, in the administration of disciplinary punishments, the conduct of summary trials. And again, countries have different words for the same phenomenon, but this is how do you deal with minor disciplinary matters? And I think there's an increasing, I don't know that there's a trend at the moment, but there's an increasing anxiety that this is an overlooked area. And if I can, I'll say two other things about overlooked areas. And I don't know if this is quite responsive to your question, Vikas, but the two other areas are, I believe that the correctional programs, right, for military prisoners is a very understudied area. I think this is basically unknown territory. And maybe because of the COVID-19 situation where people are looking at prisons in ways that they haven't in the past, maybe that will spark some interest in that. And the other one is, and here I'll talk as a lawyer and a law teacher, the number of ethical issues that seem to come up, questions of professional ethics. I think that is there's some attention that's been paid to it in the past, but I think you're going to see more and more attention paid to it. As more and more cases involve lawyers, inevitably, show me a lawyer and I'll show you ethical questions. So let me leave it at that.
So could you just throw light on some cases in different jurisdiction that you consider as landmarks insofar as military justice is concerned?
Sure. In the UK, of course, there's the FIDELL case, which wound up at Strasbourg. I mean, who knows where things are right now after Brexit, but actually Brexit doesn't affect Strasbourg, so I shouldn't make that connection. But all the cases that have been decided in Strasbourg that have affected and dramatically changed the UK justice system. FIDELL is only one. Martin against the UK is another one. Those in turn have had a kind of hydraulic effect around the world. There's a case in Canada having to do with judicial independence called EUGENE some years ago, and there's a very recent case called Stillman that everybody should read from the Supreme Court of Canada about what are called service offenses. In other words, an offense under civilian law which is absorbed into the code of service discipline. And that's a common phenomenon in those military justice systems that are British inflected. There have been major issues in South Africa about the independence of the prosecutor. Interesting issues there. And in the US, we've had a host of issues a surprising number of which have actually gone to the US Supreme Court, whose jurisdiction, of course, is entirely discretionary, well, for all practical purposes, entirely discretionary. For example, the Solorio case. What if an offense has no connection to the military, aside from the fact that the accused is a serving member? Held in 1987, Dwight can correct me, 84, 87, held. That doesn't matter as long as the individual is in the military, that's it. And that seems to be the law in Canada as well. I will tell you, I'm involved in a case right now that raises very substantial issues, which I can get into later a little bit maybe, but it's a pending case, so I'm a tiny bit tongue-tied, but it has to do with the exercise of command influence by the President of the United States. And unfortunately, we have had a string of issues where the president has meddled in individual cases. The president and other political leaders have meddled in individual cases. And I would say, I don't know if it's a trend around the world, but what I'm seeing is very, very disturbing. And we may know more about it in a few months' time, and if the case goes to the US Supreme Court in a year or two. So that's some idea of where the major issues have gone.
That's a good insight. We, while sitting in India, could just have a peep into it. So could you just tell us about the historic Yale draft of 2018, prepared by global military jurists, related to the existing UN draft principles of military justice, wherein you had improved upon the United Nations military justice principles and handed over a new draft to the representative of the UN. What was your experience and what is your take on that?
Right. This was in 2006, the UN Office of the High Commissioner for Human Rights sponsored a set of draft principles governing the administration of justice through military tribunals. These are the so-called DECAUX principles, D-E-C-A-U-X. The primary leader of that effort was Professor Emmanuel Decaux from the University of Paris. Basically, this was an effort to come up with, let's say, generally accepted principles for how military courts should function. There were a few pressure points. I mean, were you ever going to permit a trial of a civilian in a military court? There are countries that do this repeatedly. They still do it. I mean, Uganda does it every Monday and Thursday. It's unbelievable. Egypt and a number of the other North African countries. So there were major issues, issues of where you would try human rights violations. Suppose you have military personnel who engage in grave human rights violations. Do you trust the military justice system to prosecute those, or do you say, no, those are off the table, those have got to be tried in a civilian court? Anyway, for a number of reasons, the DECAUX principles sort of ran aground. They lost their steam. They never got the final blessing of the General Assembly, and they were just out there. And when I frankly stumbled across the DECAUX principles, I can't recall where I first learned about them, but I got involved at the tail end of that process, and I watched with horror and disappointment that the steam had gone out of the effort. And finally, thanks to Yale Law School support and the goodwill of a number of people, and in fact, some who were involved here, I see NAVDEEP, and I think Dwight was involved in this process, we ran a relook at Yale Law School. We had a workshop on the DECAUX principles. We put our heads together. We had some wonderful student research assistants, and we updated them. And it turns out that in the time since 2006, even though the General Assembly had not, performed the benediction over the DECAUX principles, slowly, the DECAUX principles were kind of seeping into the discussion. You'd see references to them in human rights, the NGO literature. You'd see references to them in national court decisions. You'd see references to them on the floor of the House of Lords. Who knew? You know, eventually, it just seemed that we had to do something to move this thing forward, and that's what we've done. And after a lot of preparation and a very intensive weekend of work, we had a draft that was smooth enough that we passed it off to the special rapporteur on independence of judges and lawyers. That's the mandate holder at the UN whose portfolio includes this kind of thing. And we're frankly hoping that the UN will find the time and find some sponsor, some national sponsor, to light a fire under this project. That would be a good deed for the Indian government, by the way. Anybody know anyone in the Indian government while I have you? It would be nice if somebody in the foreign ministry were to, you know, send a telegram to Geneva and say, why don't you hold another hearing on this stuff and let's get rolling, because there's no reason why we shouldn't have a 21st century state-of-the-art set of generally accepted principles where we could help countries that are grappling with these issues to, you know, to get modern, sensible procedures, institutional arrangements that foster public confidence in the administration of justice. I mean, the only country I know right now, actually there are two, South Africa and Fiji, are in the middle of major overhauls. But, you know, they're taking divergent positions. I think, at least in Fiji, it will be a compliant system because I know who the person is working with the Fiji government. And he, in fact, was involved in the Yale workshop. But I think this is really an effort that people should study. And the Yale draft principles are available on the website of the National Institute of Military Justice, excuse me, on the Global Military Justice Reform blog. Let me say that again, Global Military Justice Reform. If you simply type that into your search engine, it'll take you to the website, and then use the search function on the site. Just look for Yale draft and you'll get it. And I hope everybody takes a minute and or a few minutes to see what's there. And, you know, if we got things wrong, I'd love to know about it. If we got things right, tell the UN.
It's a good take, and especially the persons who will try to Google today will not feel difficult because the topic itself, it's divided into two parts. And the first part deals only on this global justice reform. So while Googling that, it will be easy.
Great.
Thank you, Professor FIDELL. We are having questions. We will have at the end of it. Now I will just pose certain questions from AISHWARYA Bhatti. If there had been something like TRP on the social media, once after the judgment on the short commission, I think if anybody could just go on the upswing of the social media on the TRP part, if it is to be correlated, I suppose you are the one who has actually created history. It's the entire different, I can just see NAVDEEP just passing on the smile because he has also immensely contributed in that. Nobody can shy away from the fact that both of you have contributed tremendously for the military service. Because since that judgment has a relevance, and though it was widely covered in the media, etc., we are feeling enamored on the fact that we are having you on this platform of Beyond Law CLC to have the insights, as we say, straight talk from the person who was at the helm of the affairs, NAVDEEP and AISHWARYA. AISHWARYA, could you just tell your experience towards this recent landmark judgment of the Permanent Commission to the Women in the Army? How was the journey from the Delhi High Court to the Supreme Court? What challenges were you faced? How did you actually, you and NAVDEEP, thought of looking into the law? Once there's a settled law, it's not difficult. But if you try to build something on a different pedestal, sometimes at the first instance, myself being a lawyer, I find that sometimes once you are there, at the back of the mind, you always face what difficulties there could be. And as a lawyer, you would also have to see as to what are the challenges, what the judge can ask, and especially once you have won the first round and second going to that. Firstly, share your experience on that, and that what were the challenges within the mental block, how to go about it, and how to actually hammering the point in the right perspective. First, we will take your take and then Navdeep.
No, I must clarify though that I wasn't involved in the permanent commission case in the litigation per se. I was involved in the tribunalization case with her.
Okay,
So it's entirely her effort and her victory, and we are so proud of it.
Well, thank you.
The mental sport. The mental sport is always enough.
No, thank you. Yeah, of course. Thank you, Vikasji. My very warm greetings to all of, to everybody who's here from different time zones. It's a beautiful day here in Delhi, I can tell you, and I'm sure it must be a beautiful day after being having very hot days for several days. You know, whether actually Navdeep ji and I have been sort of partners in military issues and military justice matters everywhere, you know, that we have. And even if Navdeep ji and I are not really working together, I always make a point to, you know, pick his brain and, you know, run my thoughts through him. I ran my written submissions through him in this matter, and I have called him umpteen number of times. I take him as a friend, philosopher, and guide in all military matters. And why not? I mean, a person who's your friend with such immense experience available to you, you must take. And these are issues which, you know, take the nation forward, which are important issues, not just for nation, but for, you know, for gender justice across the world. It was, frankly, Vikasji, for me, it was a privilege to be part of this journey. It was incredible that I got to be the lawyer for this incredible journey and representing some really courageous and brave women who were assets, who are assets, continue to be assets for the Indian Army. Indian Army's judgment was the first one to come. We subsequently had the judgment for the naval women officers also. The Air Force officers matter is still going on. We will expect a judgment soon on it. But of course, it's once the Army judgment is there, it's a dominoes effect for the rest. You know, sharing some of the challenges that we had. Of course, Delhi High Court gave us a great judgment back in 2010 itself, March 2010. Bench of Justice Sanjay Kishan Kaul gave the judgment and said that permanent commission has to be a given. And it was on very interesting, you know, parity. And they said that if women are good enough for short service commission, then they're good enough for permanent commission. Actually, it did not tinker with the military policies of having them in newer areas or, you know, newer arms or combat roles. Or in fact, that was not even in the issue. But it was actually, you know, in a very beautifully simplified form and acknowledging parity. Unfortunately, the battle in Supreme Court took a full decade, and the union's petitions were filed soon after in 2010, and they remained pending. We saw a lot of political dilly-dally, and, you know, initially we saw that the government wanted to give a permanent commission. Subsequently, after much ado, it was announced in 2018 that as a policy decision, they are granting permanent commission to women officers. But interestingly, even after that policy decision having been taken by the highest echelons of the political decision making, when it was being implemented, the notification that came in March 2019, which granted permanent commission, even in execution of it, they found disparity. So the authorities wanted to not give the benefit of permanent commission to existing women officers who had been fighting this battle. They wanted to apply it prospectively. And another very strong issue that we raised before the court was that in the execution, they said that they will confine women officers to just staff appointments. Now in the military, there are criteria appointments and there are staff appointments. Now criteria appointments, you know, in common parlance are like the meteor roles. They are the command positions. They're you know, not just desk jobs. They are better positions, better roles. We raised an issue that, you know, even while granting permanent commission, the government is actually discriminating with them. And then the whole battle started all over again, and we saw excuses being made, all kinds of excuses about biological duties of women, them being inferior, you know, they're having maternity duties, and you know, men not being stereotypical, men not being able to take command from women officers because of their social background. All these kinds of arguments were raised before the Supreme Court. And actually, I felt that those arguments became the pivot for this strong judgment to come. If these flimsy arguments had not been raised, I mean, it's 2020. You can't raise these kind of arguments. And interestingly, when we did research of similar battles across the world, we found that it was this very same kind of arguments that had been raised across different jurisdictions. So it's very interesting that on gender issues, it's very uncanny actually, that on gender issues, geographies or the level of developments, or where, you know, the aspirations of the society or the modernization has very little impact. And it's the same kind of issues that are thrown at women, you know, on different points. And I'm like really proud to say that Supreme Court called the bluff. They called the bluff, and they demolished the entire argument. And they said that, you know, battling gender parity is like is confronting the mindset. The problem is really with the mindset. The stereotypical mindset is the problem, and the constitutional guarantees and dignity does not have any space for these kind of arguments. What is also amazing is that the Supreme Court has examples of these amazing women who had been performing. It was not like, you know, we were dealing with an experiment anymore. Women have been in the Indian military services, in the Indian Army, Air Force and Navy since 1991, 1992. So having been, you know, performing their shoulder to shoulder in their military duties, to today call them that, okay, no, you're good enough only for 5 years, 10 years, or maximum 14 years, but sorry, not for 20 years, or you're inferior. It was a bluff that was completely demolished by the Supreme Court in very strong words. And I realized the full potential of it only after we got the judgment, because I had calls from people across the world, people who were interested in this journey and who wanted to tell our story. And, you know, it was covered by media across the world. And it was wonderful that actually privilege for me that I was part of it.
One issue which was a common man or any other person would like, was it being opposed by the government itself, or there were certain men, etc., oriented, moving an application for implement, saying that this shouldn't be done, it will hamper in this way? I just wanted an peep into that.
So, Vikasji, there were no implement applications by gentlemen officers. In fact, you know, getting from there, we gave to the court some examples of some of the communications that happened between these women officers and their Jawans. You know, the Jawans addressed these women officers as Sabji. There were very interesting messages that said, you know, Sabji tadke aap CO banoge, Sabji badhai ho. And these women officers said these men who are supposed to be from that, you know, that rural background that they can't probably take command from women, they don't even see us as women. They see us only as officers. That is why they don't even bother to call us as ma'am. They are fine to call us as Sabji. Sabji is like sir, for those who are not familiar with the Hindi language. So I think the problem really is the mindset of the institution. The problem is really with, you know, trying to use women, you know, for or showcase them as role models, or, you know, parade them on the Rajpath, or, you know, today we have women doing even in the combat roles. We have women in all the 3 arms in the combat roles. But increasingly, I mean, the system actually shuts its door when it comes to changes. And when it comes to gender issues, I think they're the similar kind of problems. So that's how my experience was.
Somebody had just asked what would be the title of the case. So I can tell.
Yeah, Babita Punia. It's Secretary, Ministry of Defense, Union of India versus Babita Punia. That's the army matter, and the naval matter is Union of India versus Annie Nagaraj.
Okay. Do you find that you have dealt with this army as well as Navy, now the Air Force? Are there any subtle differences of line of arguments, or according to you, it will flow in the normal one?
No, there are differences. In fact, so the Army kept on resisting till the end, but the Air Force and the Navy had granted permanent commission to women officers in 2006, 2007, and implemented it from 2008. But they also implemented it prospectively. So there was this battle for women officers who had been short service commission officers prior to 2006, and they had been denied prior to 2008, actually, when they executed it. But interestingly, in the Navy matter, the Union of India argued that there is really no gender discrimination, because this is the same criteria being meted out to gentlemen officers of the Navy also, and they don't mix streams. So all short service commission officers stay as short service, and permanent commission officers are permanent commission. actually we had to take the plea of facially neutral discrimination, the cause effect, because there are some legislations which on the face of it appear to be neutral, that, oh, well, we don't give to women, we don't give to men. But you have to dig a little deeper. You have to scratch the surface and see what is the effect of it, what is the impact of it. And then you realize that for gentlemen officers in the Navy and the Air Force, they were two, there was a broader door of permanent commission available, and there was a smaller window of short service commission available. So it was not like they did not have the bigger door available to them. And for women officers, that bigger door opened for them only in 2008. So ultimately, our battle was that you can't have gender as a disqualification. You have to assess their suitability and their merit, and it can't be that gender cannot give them something extra, but again, gender cannot be a shutdown for them for anything that they rightfully deserve.
And ma'am, what is your take that since you and Navdeep have worked together on military-related litigation, in some cases, you have worked together, including for disabled soldiers and widows. What is your take on the military litigation?
Well, like all litigation fueled by the government of India, which remains the biggest litigant in our country. Unfortunately, despite a lot of effort, there were great recommendations made by the committee that Navdeep ji was part of, and they actually, Navdeep ji, I'm sure will talk more about it. But we didn't see much impact on the ground. We saw that mindless litigation which should have been taken. And after all, when you're talking about military litigation, it cannot be adversarial. There are very few things which are like court-martial related issues which should be taken as adversarial. Benefits issues, where when you're forcing widows, or where you're forcing retired soldiers to march right up to the highest court of the country for issues which are their entitlements, which are their rights. It is beyond my comprehension, frankly, and we saw very little impact. The more things change, the more they remain the same. We haven't seen any real change, and it's actually, in fact, there was a problem, but the tribunalization matter, and relating to that, we had a judgment where they said, of course, when I was hearing Professor FIDELL, it was very interesting to note that the streams are very different there. So either it is the civilian justice system or the military justice system. Interestingly, in Indian system, the military justice system also rolls into the civilian courts. So after the AFT of course comprises of judges and retired officers, but after that everything rolls into the regular courts. And there is a judicial review at different levels. So we were having problems by bypassing of the high courts. Now, bypassing of the high courts made actually the defense litigation, the military litigation, even more cumbersome, because you were forcing, and there's not just one Supreme Court in the country. That's the apex court. It's for important questions of law of general public importance. It's not for pension related issues or disability pension related issues. These are issues which have to be decided on a precedent law that is already there. But unfortunately, too many of them come up to Supreme Court, and it's, of course, government is all powerful. They have their battery of lawyers, but it's very, very difficult for soldiers and widows to fight their battles.
Thankfully, we have lawyers like Navdeep and yourself who just go whenever there's something pinching them. And the participants who are there, as Ma'am Bhatti told, AFT would be Armed Force Tribunal. That is wherein the people who have certain grievances with the armed forces go there. I will take a call from Ma'am Bhatti and then Navdeep, that what was the journey then when the tribunalization issue came? It was that the judgment came which said that after the AFT, one has to go to the Supreme Court. Then after a journey, just like you said, for the 10 years, you fought for the commissioned officers, permanent commission. That how that tribunalization came, how that Roger Matthews came, how that initial judgment of L. Chandrakumar was there, then Madras Tribunal, all these judgments, how that journey was, we will take all these issues. Ma'am Bhatti, what would you like to see the changes in the attitude of the official establishment qua military litigation, or for that matter for any litigation? As you said, once you go to the litigation, question is any organization, even though we have certain judgments to that effect, which says that similarly situated persons should be given relief automatically. Not one, but there are a large number of precedents to state therein. And there are instructions, at least of Punjab, Haryana, to the effect, which have adopted the judgment of Sadhbir Singh versus State of Haryana, way back of 2002. Now we are 18 years ahead of that. We can say that that judgment has also attained majority, because it's 18 years journey. Yet we find not only of civil law, but other judgments also, which speak of the fact that despite there being instructions issued, yet we have same rigor molds of written statement, etc. I was just reading a very old article of NAVDEEP written there, and I was just reminded, which said that the government has such a policy. Let's assume even if you have to pleading is that what you want to hammer a point. Even if you write that sun rises from the east, in that eventuality, the government will come and file a reply and the written statement to the effect, it is denied for want of knowledge, or they will come and say wrong and denied being incorrect, or they will also hammer a point that sun does not rise in the east because there are sometimes dark days also, and sun in fact never rises. So I was just reminded when I talked, I just asked Navdeep, just chip in. And when you were coming, I was thinking that yes, the government has this policy. It is just like sometimes to say that actually demonstrate that the ice would always float on water. But the government will always come with this thing. They say, no, ice will never float on the water because the ice will automatically melt in the water of the temperature, and there's no ice, therefore the ice can never float on the water. I can see Navdeep and FIDELL, they are smiling across. I will just ask Navdeep, and still we are having questions pouring on the chat box, and the participants who are there, they're also live on Facebook. We will take questions also from the Facebook as such. So we will take the questions also. I thought that we have seen a lot of Navdeep smiling, but as we say, Deep is akin to a Deepak. So he's the illuminating light on the military law system itself. He has helped us in large number of judgments. As you said, that I also sometimes bother him in the morning, late night, evening. Okay, what is the law, the military law? Just as we say, invariably, Professor FIDELL and Bhatti ma'am would agree that invariably they say that where there is a law, there is a flaw. And where there is a flaw, there has to be a lawyer. And when there is a lawyer, and especially in the military law, it has to be Navdeep Singh, according to me. And that is why he was a founder president, and his insights of that, we will ask Navdeep, what was his journey in this tribunalization, and his insights already actually sometimes break in effect. Before we ask Navdeep, as Bhatti ji was saying, I'll just ask, you said a dominoes effect. I just thought, it just crept in my mind, because during this COVID-19, that sometimes the mind is so blocked. Sometimes one relates domino means Domino's pizza. What is the domino effect according to you?
So Domino's effect is those small dominoes you would have seen. People go to a lot of length to arrange those dominoes, and they are arranged in a manner that you just need to push that first domino. And the dominoes effect is that no matter how many hundreds and thousands of dominoes are arranged in different configurations, they all come down with that one push to that one domino.
While taking leave from FIDELL, I will say in Hindi they say, "Ek cycle giri aur cycle girti gayi."
Something like that, yes.
Or a ripple of waves which continue to have their own effect in a large one. I will ask Navdeep certain questions, then we go to the Q&A part. Navdeep, continuing from the questions which we asked Bhatti ji to ask, would you like tell the state of military litigation in India? What do you feel that there are changes required in the mindset? What are the changes where people can learn? Thankfully, I was just one day, since we are also on the Facebook, despite the fact that we are also on the contact call, that you have launched a book, but during these dark days, the only way was that one could only wait on the military law book. I would also like what you have written on that book, what help it can help the lawyers as well as a common fraternity on that judgment, and your journey while writing as a lawyer, what is that? So what is your take on this military litigation, or for that matter, any litigation where law, you know it very well, that once litigation has been done?
Yeah,
Yes, ma'am.
just as can you hear me?
Yeah.
Yeah.
Yeah. So just as Ms. Bhatti was saying, and you also referred to one of my old op-eds, that's a true real life incident wherein a judge said that if you file a writ petition saying that the sun rises in the east, the Ministry of Defense or the Army will file an affidavit saying, no, sir, the sun rises in the west. So that's actually a real life incident. It happened in our High Court. So see, on a more serious note, the thing is that what change I would like to see is on the military side, especially for many of our young JAG officers who are also right now on this webinar, that I would like them not to get personally involved in litigation. The biggest problem in military litigation is that it's mostly a litigation of ego. It's mostly, a litigation of prestige, that even if a case is not made out, you get so much personally involved that, oh, how did this person, win a case against the mighty Union of India or against the army? So that attitude must change. And if you want to fight out a case, please fight it out on a legal issue. Please definitely appeal against it or file a writ against it if you actually feel that there is a legal point involved and it will set a wrong precedent. For example, in many cases involving discipline, or even in certain cases involving promotion, as Ms. AISHWARYA was saying. But if you just make every single petition a prestige issue, that no, we cannot allow the person to win, then I think it's a downhill. And that's why I say, when I compare litigation, with the Ministry of Home Affairs in the High Court, or even with Punjab and Haryana, there are times when there is moral courage shown, and the officer concerned who's present in the court would say that, yes, my lord, it's a covered case, or that, yes, we should concede, or they simply say that, yes, a case is made out and we were wrong. But over here, there is so much of fear, and young officers who are defending cases are under so much of pressure that they want to win cases, just win cases by hook or crook. And there is so much of pressure from the outside that, there are signals coming in, there are telephone calls, and they're going out, sir, this happened in the case, and the senior guy will say, oh no, please tell the court this, don't lose this case. So getting personally involved in any litigation is not a good idea. And this is one thing which I would like, this is one aspect in which I would like to see a positive change, that the system, the military hierarchy must remain totally dispassionate about litigation. Fight it out on points, on legal issues, but don't get personally involved, and don't make it a win or lose situation in such a manner that as if you're fighting a sport, as if you're in a sports tournament that you have to win at any cost. So that system should change. So yes, and also we have also seen that at many stages and in many cases, the political executive would have a different opinion, but the lower functionaries would come up with such excuses on file notings, etc., that they give an entire twist to litigation. For example, the case in the permanent commission issue, Mrs. Bhatti knows it very well, that the Prime Minister himself made a statement, from the Red Fort, that we are going to grant permanent commission to women. Later on, the submissions in the court were absolutely at variance with what the political executive wanted. And I must place it on record that once Ms. Bhatti won that case, the next day, the Raksha Mantri, the defense minister himself, tweeted that he was happy for the fact that the women had won the case and Mrs. Bhatti had won the case, in the sense saying that I'm happy that we lost the case. So even there are cases wherein the political executive has a different opinion, and later on in courts, the lower levels or the officials down below, give an entire spin to the issue. So these are the things I would like to see. I would like to see a change in bringing in a little more moral courage and not getting personally involved in litigation.
So your take and my experience has also been, why we restrict only to the military? I have seen, for that matter, any institution invariably comes with the same, despite the fact and as a lawyer, you will always find that even if we mention it and as heart within heart, like Aishwarya as a additional advocate general of UP also, then as a lawyer, one will always plead the facts and that the judgment of are distinct and distinguishable. That would not apply to the said judgment. So that continues to hover, but as a fair counsel, ultimately, even if we speak on that, ultimately, as a fair counsel, you would always say, yes, we have taken a stand, but without the concession, the judgments are to that effect. Then this, Ms. Bhatti, and you can share, what has been your experience, this tribunalization, this journey, that L. Chandrakumar's judgment, then judgment to the effect that no AFT was straight away with the leave of the court, which you will find that invariably in other acts, at least I have experienced, there was nothing seeking a leave that you should grant us the leave that we have to go to an SLP or for that matter the High Court. Once it is a take, that bench, the higher forum where you go, would automatically take as to whether it's a fit case or not. But to take a leave from that court itself to the effect that, yes, kindly grant me the leave, I want to challenge your order. At least heart within heart, I've not been able to reconcile to that fact that asking that you should have a certificate that you can go and challenge that. What is your take on that?
Yes, I would just give a background of tribunalization, and Mrs. Bhatti and I were involved in this issue very deeply. See, firstly, let's not forget that tribunalization is the resultant of the emergency. It came out, through the 42nd Amendment, the 42nd Constitutional Amendment, and it's an emergency era, system. Except, for example, we had Income Tax Appellate Tribunal, which came about in 1941. And etc. and other tribunals within the judicial system. But the tribunals that we see today, CAT, AFT, NGT, etc., these are a resultant of the 42nd Amendment. Now, the idea at that point of time was that take out the jurisdiction of constitutional courts, give it to these executive controlled or executive manned bodies, and in a way hamper or put obstacles in the way of judicial independence. So that was the idea behind the 42nd Amendment, through which tribunals came into play. But over the years, the High Courts and the Supreme Court, they chiseled away many of those draconian provisions and interpreted things in a manner that there has to be independence of tribunals, and the system cannot be so far removed from the regular judicial system that a person says that this is a body which is functioning under the executive. But unfortunately, those judgments have not been complied with properly. Now, for example, L. Chandrakumar said that direct appeals to the Supreme Court would make justice inaccessible and unaffordable. She flouted to the hilt in many acts, including the National Green Tribunal, the Armed Forces Tribunal, etc., etc. Of course, now it has been toned down by the Supreme Court, but a total contravention. Then Madras Bar Association said that you have to give longer tenures to members, so that R. Gandhi said that give longer tenures to members to ensure stability. Again, flouted to the hilt. And currently, let's take the example of Armed Forces Tribunal. Judge can at best get 3 years. After retiring from the High Court at 62, the person retires at 65 from the tribunal. So 3 years is a maximum, and practically speaking, they're just getting about 1 year, 1.5 years. So again, flouted to the hilt. Then Madras Bar Association 2 said that the secretary of the department against which the tribunal has to pass orders will not sit in the selection committee. Again, flouted to the hilt. Let's see, for example, in the Armed Forces Tribunal, the Defense Ministry is the first party, but the Defense Secretary, through the Defense Secretary, and the Defense Secretary is also part of the selection committee, which is selecting adjudicating members. So the tribunal functions under the thumb of the opposite party, and the person, the secretary of the department concerned, himself is sitting for selecting members. And then the infrastructure, the manpower, etc., is all controlled by the Ministry of Defense. And this affects the tribunals, those tribunals more, wherein the other side is mostly the union, including the National Green Tribunal, the TD-SAT. It does not affect certain other tribunals, for example, consumer commissions, etc. It doesn't matter whether it's functioning under the government or not. Then L. Chandra Kumar and R. Gandhi again said that all tribunals should be placed under the Ministry of Law and Justice and not under administrative parent ministries against which they have to pass orders. Again, not implemented. And in Roger Matthew, these rules which again emasculated, so to say, the functioning of tribunals was struck down with the help of Mr. Datar and Mrs. Bhatti. But again, the new rules are a reflection of the old rules. So the journey continues, and even after getting, around 20 judgments from the High Courts and the Supreme Court, including constitution benches, we are still scratching the surface and we haven't reached that stage of independence that we should get. Now, coming to the AFT, see, the court-martial system, even in the Indian jurisprudence, is a little flawed, and it contravenes the International Convention on Civil and Political Rights, Article 14, which says that you must have an independent, impartial, and competent tribunal, which also covers military tribunals, that is courts martial. But our system is that the jury, the judge advocate, the prosecution, and the evidence collection system, everything functions under the thumb of one single authority, which is the authority which is looking for the conviction of the person. So there is no independence, there is no prosecutorial independence, there is no independent director of prosecution, there is no one to oversee that the prosecution is independent, so to say. Even the basic independence is lacking. So Prithipal Singh Bedi's case by the Supreme Court, they said that you must have one level of appeal over courts martial, and that's how the idea of AFT came about. It was only meant to be an appellate court for courts martial, not for service matters. But when they started, drafting the act, they included service matters also on the lines of a central administrative tribunal, and they made it a hybrid kind of a tribunal which would hear appeals against courts martial and also determine service matters. So that is how the AFT came into play. Another thing in tribunalization on a whole is that these bodies were created to take the burden off the regular judiciary, or to say that they'll provide inexpensive justice and the pendency will decrease. However, I fail to understand that when instead of a court, you're arguing a case in a tribunal, how does it reduce the burden on the costs or the burden on the pockets of a petitioner? I fail to understand how is it inexpensive. One. Two, pendency is also a myth. To take the example again of the AFT, at the time of the creation of the AFT, the pendency in the high courts was 9,000, and the matters were transferred to the AFT, saying that, oh, the high courts are getting overburdened with such cases. Now, as on date, the pendency is 17,000, I think. So whereas the pendency has not reduced, and this demonization of the high courts, saying that they will be overburdened or we require expertise, I absolutely disagree with that, because high courts are constitutional courts. The Supreme Court is a constitutional court. Nobody can emulate the independence of a high court. And this expertise is also, I personally feel that it's overvalued, because in fact, getting an expert into the system of tribunals makes since experts are over familiar with their matters and have worked in the same system, it makes justice subjective to an extent. Although yes, expertise can help, but I think this has been blown out of proportion, that some kind of expertise. Tomorrow somebody will say that a district judge should not go into medical jurisprudence unless you have a doctor sitting with him. Or you'll say that tax matters should not be dealt unless you have a retired revenue service officer sitting with the judge. So judges are supposed to be experts of experts, and the duty to provide expertise is of the two sides. One side is arguing one way for a petitioner, the other side is arguing for the respondent. So they are supposed to provide expertise to the bench, and the bench is supposed to decide the matter. And so I sincerely feel that although tribunalization, in some form or the other is, unavoidable for purely technical issues or where a high degree of scientific expertise is required. But to say that everything there should be all-round tribunalization, I don't agree with it. And excessive tribunalization must be resisted to preserve the independence of judiciary. Now, coming to your point of directly going from the AF to the Supreme Court, that was a death knell for litigants, because expecting a litigant to appear in the Supreme Court for defending small little things is a gone case. And the AFT Act used to say that, it still says that you can approach the Supreme Court only if there's a point of law of general public importance, which is in 99.999% cases, it is impossible. General public importance in a pensionary matter or a service matter, or even in a court martial, is absolutely impossible. So it's great that with efforts of Mrs. Bhatti and Mr. Arvind Datar, that we ultimately got a judgment. Although one larger bench is still pending, but that judgment says that no, you cannot take away the jurisdiction of the High Court at all, and asking people to approach the Supreme Court directly makes justice unaffordable and inaccessible. They've reiterated L. Chandra Kumar. They've said that no, High Court cannot be taken off the grid as far as military matters are concerned.
Before we proceed further, I will just ask, because I was just seeing that since Aishwarya ji and you, as a lawyer, sometimes you are so well versed with the facts. Sometimes they just it's just like you are dribbling the ball in while playing a hockey. You don't even realize that the other participants are just watching. You said Roger Matthews. I would just say Roger Matthews kindly explain that, R. Gandhi, and what is the take on that? Because large number of participants, especially on the Facebook or on this platform, might not know what did actually this R. Gandhi, what terms did it contemplate, and what did this Roger Matthews say, at least for the benefit of the other people.
Yes.
I am knowing it.
Yes. So R. Gandhi was the matter in the Supreme Court Constitution bench, again argued by Mr. Arvind Datar, who has been a great support to me and Mrs. Bhatti, also personally, senior advocate, a great person. So R. Gandhi was argued by him. So R. Gandhi said that it was dealing with the Company Law Tribunal, the NCLT and the NCLAT. So they laid down a few principles. The first principle was that the tribunals must function under the Ministry of Law and Justice and not under the parent administrative ministry, not yet implemented. The second principle was that you should have a longer tenure for members, at least 5 to 7 years, not yet implemented. The third thing was that you cannot have vague criteria such as a person can be an expert in management, accountancy, business, etc., and join as a member. Again, in the new rules, still we find such clauses. So for other tribunals, not yet implemented. Then came Madras Bar Association, in which the entire National Tax Tribunal Act was struck down, and the tribunal itself was quashed, saying that this tribunal cannot, be instituted, incepted. So in that case also, they said that the tribunal will not function under the same ministry against which it has to pass orders, and that it must have full independence, and that the secretary of the concerned department will not sit in the selection of members, again not yet implemented. L. Chandra Kumar, of course, is the first 7-judge bench judgment dealing with these matters in a very detailed manner, wherein it said that direct appeals to the Supreme Court cannot, be it cannot be incorporated in law that you go directly from a tribunal to the Supreme Court. That is impossible. You cannot take away the power of judicial review of a High Court, which is also a constitutional court. Then L. Chandra Kumar also reiterated that the Ministry of Law and Justice should take control of the tribunals, and you must have an independent agency. Then again, it spoke of much of independence, etc. And Roger Matthew case was a case wherein the Supreme Court has now reiterated these principles and said that when you make rules concerning the tribunals, please follow the law laid down in all these landmark judgments, all these constitutional law judgments, constitution bench judgments. So that is Roger Matthew, and they've struck down the offending rules, and they've also said that reiterated that no direct appeals from the tribunals directly to the Supreme Court, and please rework on the rules wherein these direct appeals have been provided.
I will take a call from Aishwarya ji, I think this principle that the ministry who's under whom that tribunal will come should not be part of the constitution. I think the principle, broader principle would have been that nobody can be judged in its own case, number one. And number two, let's assume the person who is appointing him, it would always, the person, as we say, there are certain types of biases. So probably that factor of bias to the effect that the person who is appointed by a person against whom the decision is to be given, probably that factor slightly might hinge in the mind of a judge, howsoever he may have been appointed, that he could have, that he has been appointed by that authority itself, and then let's assume the judgment is there, and then you pull them up on that ground that you are not implementing the judgments. What is your take?
You're right in pointing that out. In fact, our petition did mention many of these grounds, which are seemingly small issues, but I mean, we have to see that the cause of justice dispensation has to be taken at a completely different level. The kind of immunity that is provided to the judges of the constitutional courts and judges who are dispensing justice even at the lower judiciary levels, that immunity, that independence, that segregation is necessary so that they can carry out their duty without fear or favor. You know, it's not just about appointment, Vikasji. The rules prescribed are so lopsided that for leaves, for getting a leave from as a judge, or you know, for approval of that, for getting a house, for some other benefits. I mean, for everything you have to pretty much go to the person who is the first respondent in your court when you are dispensing justice. It doesn't work like that. You have to give the idea of justice dispensation a higher pedestal. You cannot have the respondent ministries, you know, approving their leaves and benefits, etc. So that's a huge parity there.
Of course, Navdeep and Mr. Fidel would also agree that as long as there is no independent thought process, or they are not actually, the strings of their control, I would say in a different way, are not in the hands of those persons, till then the judgments would not, in all fairness, though we haven't faced such things, but yes, these do affect the delivery justice system. And another issue, what Navdeep was saying, that R. Gandhi and all said that give a 5 years, 7 years terms. Like we all know that there are certain tribunals for the term is for 3 years. A judge completes his 3 years term, and for good 1 year, we don't even have an appointment to that. And Navdeep knows it like an AFT. In large number of cases, like we all know that there are two set of systems: a judicial member and an administrative member. In certain tribunals, we are only having one judicial member, and certain tribunals, we are only having administrative tribunal. The quorum is not complete. The entire staff is being paid their salaries, but we are not being able to hammer the point. The litigants are suffering. The tribunalization, which was great, was a creature of the mindset to the effect that it would reduce the burden on the heavy dockets of the High Court and the Supreme Court. But the tribunalization, the tribunals which were created for speedy justice, sometimes the cases are not being decided only because of the want of the appointments. What is your take on that, Navdeep and Bhatti?
I'll let Mrs. Bhatti reply first.
No, Navdeep would have been, anyways, okay, now that you put the ball in my court, see, there is an important maxim that goes on with justice delivery, that justice should not only be done, it should appear to have been done. And, you know, our system of judiciary, of course, we've been bickering so much. I'm a little skeptical what Professor Fidel and some of his other colleagues must be thinking about our system. But despite our deep issues, I mean, our justice delivery system, our military justice system, our military forces are amongst the most respected in the world. We are trying to iron out the problems that are there. We are trying to red flag the issues which can be prospective pitfalls vis-a-vis issues that are best practices across the world. So when Professor Fidel was talking about the Yale drafts, I have not seen it. I will take the time and look at it. but we need some of these uniform practices. For example, on gender issues, a huge amount of work has happened, whether it was, domestic violence issues, whether it was cruelty issues, whether it was, other issues that of violence that women face. A huge pressure has been formed by the pressure group that exists by international agreements and norms and treaties. So similarly, we have to have that kind of a pressure group also existing. Though I have my, reservations about the issue of the so-called violation of human rights by military forces, because I've also been involved in some of the ASPA cases, Armed Forces Special Powers Act, and we saw that some of our officers who are in the line of fire, and India has very unique circumstances in that way. But one major part of our territory, there is a proxy war being waged, and in that proxy war, otherwise the job of military is not for not their operation is not in the civilian areas. Their operation is on the line of control or the border areas. When the proxy war becomes so muddied that it is important to bring the army to operate there, that is when the Armed Forces Special Powers Act gives them that operational functional maneuverability, so that they can go on and carry out their work. Now, in that, we have seen in India particularly, there has been a huge problem of FIRs, false FIRs, and exaggerated FIRs having been lodged against our soldiers and men working in those areas. And then, what is expected is that these people will continue to go there as accused in those FIRs, continue to face the system of trial, etc., for doing something that they have done in the line of duty. When the military justice system has the power, the potential, the wherewithal to deal with these offenses, then they have to be dealt with there. And India does not have a system where military justice is maybe like we give example of our neighbor Pakistan the most, because we are familiar with their functionings. So it's not like there that military justice system is it's like a tight box there, that it has nobody has recourse to the civilian courts or the constitutional courts. That's not the case in India. So some issues by the best practices, but of course some operational flexibility for peculiar situations that exist in countries.
I would just ask, we have discussed a lot.
Yes.
How does it operate? How does it operate in? I will ask Professor FIDELL. How does it operate out there?
Let me make a couple of observations. Maybe this will answer the mail, but if I don't, ask again. As I've listened to the conversation, these things occur to me. The first has to do with the Armed Forces Special Powers Act, which I am aware of, and I'm aware that India has wrestled with it repeatedly. To me, that opens up the question of who should have the power to decide where there is concurrent jurisdiction between a civilian and a military process. This is one of the pressure points that countries face. And the notion that the military commander should be the tiebreaker, and not the tiebreaker, have the first and last word really, as to which courthouse a particular case goes to, strikes me as unacceptable. Now, countries have resolved this in various ways. There might be a memorandum of understanding as between the director of public prosecutions and the director of service prosecutions. It might be resolved, or it might be simply committed to some court. And if it's committed to some court, which court system should have that say? Anyway, I just want to set that aside. It's the problem of concurrent jurisdiction. The second thing is, and here I'm thinking about NAVDEEP's comments about the AFT and tribunalization in general. I would simply raise a question mark, and I can say this based on US experience, as to the need for specialization I'm not talking about the Inland Revenue Tribunal, whatever. I'm sure there is one in India, but you know, the tax authorities. God forbid I should ever get involved in a tax case. But as the military justice system increasingly inevitably assimilates more towards the civilian criminal justice norm, and particularly as the military justice system continues to concern itself with offenses that are not inherently military, I have to say that I'm increasingly skeptical about the need for specialization. There's no reason why competent appellate judges can't, based on capable briefing and capable oral argument, grapple with essentially any issue that could be raised under the military justice system. As my friend Dwight, who's listening in attentively, knows, most of the cases that are decided by our U.S. Court of Appeals for the Armed Forces, which is a civilian court, by the way, have concern issues. Many of them concern sex issues. The majority of them concern sex issues today. It's rare that it's a classic military justice concern: mutiny, disobedience, disrespect, this kind of thing. They're today typically issues of sexual assault or other misconduct involving children, pornography. These are the norm, and I'm here to tell you, you don't need a specialized tribunal to decide those cases. So that's in response to something that NAVDEEP said. The last point I want to make is I want to forget the Supreme Court of India, forget the AFT, forget the high courts. Let's talk about the trial, okay? My assumption is that the Indian Armed Forces run hundreds of courts-martial of one kind or another over the course of a year. Is it over 1,000? What do you think? Yes, over 1,000 maybe?
Yes, sir. Easily.
Could be.
Yeah, easily. So, and we're up in that range also. It's much lower than it once was, because basically we get rid of people administratively now. My question is, do you have a functional trial bench? What are the terms of reference for the attorneys who preside in those forums that involve a presiding officer with a law degree? What are the terms of reference for those people? Do you have something that can reasonably, plausibly be called a trial judge? And if so, is that official independent and impartial? Does that official have any fixed tenure? Does that official, if there is a tenure of some kind, is it something more than simply a tour of duty? Because unless you, I understand you want a good appellate system. I do too. But the best way to maximize your chances of having a good appellate system without 14,000 cases pending, by the way, is to get it done right at the trial. And unless you have a really good trial bench that is independent, impartial, where the judges will call the shots, they'll instruct the jury, they'll rule with an iron fist if need be, they'll keep the lawyers in line, they'll keep the cases moving, they'll generate a record that lends itself to meaningful appellate review, intelligent appellate review, you're kidding yourself. So if I were the Minister of Defense, my first priority would be to make sure that your trials were being conducted in a way that that achieved all those things, because then the rest of it is easy. Well, not easy, but it's a lot less difficult if you get it right the first place. So that's I don't know if that's responsive to your question, but those are the thoughts that occurred to me.
I'll just clarify that. Firstly, we have an ad hoc jury system, and we don't have a judge on the court martial. We don't even have a legally qualified person on the court martial, except the judge advocate, who does not have a vote and who can advise. So yes, the system at the first go, but we're trying to see even our defense minister, his name was Mr. Manohar Parrikar. He had ordered a study group to go into this, which we had recommended in our committee of experts. Way back in 2016, he had ordered a study group, and he had passed orders that a study group has to be constituted to look into all these issues. But still, till date, no executive orders have been issued. So yes, we have that problem. However, it's not to say that we don't have men and women of steel who would be able to review that system and say that no, here is where you have gone wrong. However, we cannot rely on that. So we must have a stable system. We must have legally qualified people looking into these issues, and we must have a permanent tenure-based court-martial. I totally agree. As I always say, that our Army Act is pretty outdated, our military justice is pretty outdated, but the saving grace is that it's not implemented in a draconian manner. And as Mrs. Bhatti also pointed out, that at least we have the high courts and the Supreme Court absolutely looking into these matters and not saying that no, we will not, it's a military issue and we will not look into it. It used to happen about 30 years, 40 years earlier, but as of now, at least a person is not remediless, and if he or she is not satisfied with the trial, he or she can approach the Armed Forces Tribunal and then go to the High Court or the Supreme Court, as the case may be. So at least the civil judiciary has its views absolutely on the system wherever it goes wrong. But you're absolutely right, sir, that at the first go, in the first layer itself, the system should be so robust that the cases do not increase. As far as the number of cases is concerned, the 16,000, 17,000 cases before the AFT, only a very small number is of courts martial. Rest of the cases are all service matters, pensions and pay and allowances and promotions, etc. The number of the courts martial is pretty small. However, yes, being the first, the trial, the first layer of where a person has to seek criminal justice, it needs to be very, very robust.
Navdeep, the way Professor FIDELL had given the insights, thereafter I just felt that yes, we are, while we are discussing on the global perspective, otherwise we were all thinking, if we wouldn't have been on the platform, it would have been we are sitting locally and only thinking globally. But his insights have actually given a flip to our mindset also on the global. And we are having certain questions, since we would be running short of time.
I'm sorry, I'll just take half a minute more just to clarify to Professor FIDELL. Professor FIDELL, another thing, the Armed Forces Special Powers Act, what Mrs. Bhatti was pointing out, that the Indian Army is not against judicial oversight at all, and what we are bothered about is only vexatious litigation, not actual litigation, because the Act itself also only protects actions in good faith, not others. So if there's a bad faith action, absolutely we don't say that it must be protected. Only good faith actions has to be protected. Only vexatious litigation has to be protected. And there is judicial oversight also if a decision is taken that you must try this in a military court, and a person is not satisfied. That decision can be challenged in a civil court, in the High Court, or it can go up to the Supreme Court. So again, people are not remediless, whether it's the military litigants or the other side, and that makes the system a little, better in India, that the judiciary actually functions and a person can approach a forum in case he or she is dissatisfied.
Thanks, Navdeep. Now, since we generally plan a session for 1.5 hours, a lot of healthy discussions going around, and I never realized, I don't know about the other participants and all the speakers who have just stepped in, you, Ma'am Bhatti, and then Professor FIDELL, that 1.5 hours just, I never realized that 1.5 hours is over. But since there are questions, we will not take any other questions which are already on the chat box. Otherwise, it could also happen other way around, that Professor FIDELL is saying good evening to us and we are saying good morning to him.
So we should take questions from the chat box?
Yes, we can take the questions from the chat box. Anybody of you can answer. I will post the question, anybody of you can answer. Vishwas Agarwal. What changes would you like to suggest in the constitution which will help to take military justice system more effective and efficient at the global level?
Constitution does not require any change. I mean, the courts martial are already under the power of judicial review. And in fact, the latest judgment, there's Article 227, subclause 4, which says that courts martial are not, under the superintendence of the High Court. And but that, if you look into the Constituent Assembly debates of October 1949, Chapter 10, it clearly says that it is only with regard to evidence that they cannot examine evidence. So now, for examining evidence, we have the Armed Forces Tribunal and the latest judgment, which Mrs. Bhatti argued, Roger Matthews' case, and in fact, in which my case was also tagged, called NAVDEEP Singh versus Union of India, in which he was the counsel. In that, it has been clarified that 2274 only talks of administrative superintendents and not judicial superintendents. So the Constitution Bench has clarified that the bar under Article 227(4), court martial is only with regard to the administrative superintendents, that the High Court will not have administrative superintendents over court martial and not judicial superintendents or judicial power of judicial review. So I don't think any further change is required.
I will ask AISHWARYA ji, because NAVDEEP, while speaking on that platform, he feels that everybody on the platform is all from the judicial background. But once NAVDEEP comes on the platform, or Ma'am Bhatti comes, or Professor FIDELL comes, there are participants who are from the civil. So I'll just ask AISHWARYA ji just to give an insight, what is the difference between an administrative superintendent and what is the difference between a judicial superintendent? Just to make things clearer to the persons who are the participants.
Yes, well, so in layman's terms, that as easily as I can explain, administrative superintendents would be superintendents on administrative issues, how their functioning is, where they are functioning, who are the members, how they will sit, where they will sit, the administrative issues with regard to the functioning of the court martial. Whereas the judicial superintendents means examining the reason for their determination, examining the ratio of their reasoning and why they have arrived at a particular determination. So that in my submission would be the difference.
How do you support something else also, Navdeep? What is your take on that?
Exactly the same what she said, and including, for example, prescribing forms and costs, etc., whatever is mentioned in Article 227.
Okay.
So exactly what Mrs. Bhatti said, same.
Okay. I just wanted that people on the platform should know what is the distinction, because sometimes one goes with such a flow, be that as it may, I am also a part of it. Sometimes one doesn't realize that there are participants beyond the law, especially when our team itself is captioned as Beyond Law and Beyond Law CLC. So we have participants who are beyond law.
You are a resident encyclopedia in the High Court. You remember cases by citations on, you have them on your tips.
And Angad Puri asked, anybody of you can answer, do you feel that there is a need for civil interference in military court martial?
What do you mean by civil interference? What does that mean?
Probably speaking of the court interferences in that.
Oh,
Angad can, yeah.
Yeah, there's no question. Just to give you, I'll use an image that has worked for me. The military is commonly said to be a separate society. We have endless cases in the United States that say, well, it's separate society and the different rules apply and all that stuff. My concern is, and this is a matter of political philosophy rather than law, but my concern is, as a matter of democratic policy, in democratic society, recognizing that there's a sense in which the military is separate and has some rules that don't apply to other people. You don't want that ice flow to drift too far from the shore. The effort ought to be made to keep that ice flow as close as possible to the shoreline, because otherwise, I think inevitably the dangers to democratic society can get out of hand. Not to say the government will be overthrown or something like that, but it can have a distorting effect, sometimes only around the edges, but sometimes in more profound ways. And that's why countries have doctrines of civilian control of the military. They may not be written in black letter. They may just be part of the country's political value system, its norms. In our country, the president is the commander-in-chief, literally, the commander-in-chief. Now, actually, it's interesting. I don't think there's anything in our Constitution that literally prevents a serving officer from being president. But it would never happen, I think. Anyway, just a thought. I think there are some postulates that control, even if they're not written down anywhere, and you can have both ideas in mind at the same time. That yes, there are aspects in which the military, has to be able to do its own thing, and there are customs and traditions. We get all that. Anybody who's been in uniform fully aware of that. On the other hand, that's not the central issue. The central issue is the society as a whole.
Okay. This question is specifically pointed towards Major Navdeep from Angad Puri. Would you please shed some light on the NFU case being fought by Colonel Mukul Dev in the Supreme Court regarding disability?
No, it's not regarding disability. That's regarding non-functional upgradation. That is sub judice. I mean, no light can be shed by me. It's a sub judice case and it will be decided by the Supreme Court of India. Can't comment on it. I mean, it's pending. Officers had won the case before the Armed Forces Tribunal, and a similar case was won in the Delhi High Court by members of the Central Armed Police Forces. And now the CAPF case was upheld by the Supreme Court, and the other military case is currently pending in the Supreme Court. So can't say anything more than that. It's pending whenever it is decided. Yeah.
Again, sub judice would mean that the matter which is pending before any court would become a sub judice. I'm just clarifying.
Yes.
Yes.
Sorry.
Because sometimes one so much goes with the flow that one realizes that everybody,
that's right.
And especially once we have a professor on the platform, everybody feels that whatever we are speaking is understood by everyone.
Yes.
Can you please throw some light on recent judgment by Supreme Court wherein the non-divisibility of ordinary family pension was upheld, which is imbibed in family regulations of all three forms?
Why recent? This judgment is very, very old, called Jodh Singh versus Union of India. So it simply says that it cannot be divided in such manner. But special family pension, which I'll explain to laypersons, which is a kind of a family pension which is granted for deaths which are relatable to military service, and the liberalized family pension, which are deaths relatable to operational service. These two kinds of pension are divisible, but not ordinary family pension. Ordinary family pension is 30% of emoluments. Special family pension is 60% of emoluments, and liberalized is 100% of emoluments. But I must also point out that even special family pension is not divisible as a matter of right. It depends upon the circumstances to prevent, for example, to prevent destitution. If the parents are were absolutely dependent upon the deceased soldier and they have no other means of livelihood, in such cases, it can be divided on discretion after due investigation.
Okay. Jaideep Singh asks, can you comment on the narrow scope of AFT with public interest of larger number of defense litigants as well as the policy challenges?
Yes, that's a very good question. Can you just repeat the question because I can't see it on the chat room, please?
It's posted at 7:36. Be that as it may, I'm reading it. Navdeep ji, can you comment on a narrow scope of AFT with respect to public interest of larger number of defense litigation as well as policy challenges?
Yes, Jaideep ji is a very Jaideep Vanna is a very good friend, and yes. So L. Chandrakumar, Jaideep ji, L. Chandrakumar said that even subordinate legislation can be challenged in a tribunal, so L. Chandrakumar, the Section 14 is analogous to Section 14. The Section 14 of the Administrative Tribunal Act, which was in L. Chandrakumar, it is analogous to Section 14 of the Armed Forces Tribunal Act. So one view is that since L. Chandrakumar says that even the tribunal can even quash subordinate legislation and quash policies, the same would apply to the AFT. But another view is that a recent view in the case of NGT in that I think Sterling case, wherein the bench held that no, the tribunal cannot exercise the powers of constitutional courts, and it is only the High Court which can strike down such policies or take such a decision. Now, the matter went to the Delhi High Court recently in a case last year, wherein a very funny situation emerged. Before the AFT, the Council for the Union of India took a view that the AFT cannot look into policy matters. When that person went to the Delhi High Court, the Council for the Union of India took a view that no, they should go to the AFT. So ultimately, the Delhi High Court said that no, the AFT has already taken a view that they will not interfere. Hence, now we are interfering, and we hereby quash this particular policy. The matter went to the Supreme Court. The judgment was affirmed by the Supreme Court in the first court. Leave was not granted, and SLP was dismissed. So that's where the matter stands now.
We will take, since we are running already gone beyond the schedule. Last question from it's to Aishwarya ma'am. Please throw some light on Gopiram case led by your good self, which is still ongoing in Honorable Supreme Court in relation to validity of Section 30 and 31 of the AFT case.
It's the same, Aishwarya ji. It's the same one.
Yeah. So, well, we challenged, very ambitiously, we challenged the validity of Section 30 and 31 because the manner in which it was interpreted, but that is just a ambitious overthrow, but there are alternate prayers in that. And now there is really the steam is off from this because of the judgment of Navdeep ji has explained already at length, where they have already said that the High Court cannot be curtailed. In any case, the AFT itself, the statute itself said that judicial review under Article 226 is preserved by the AFT. And that has been now emphatically held so by a larger bench of the Supreme Court. So there's really no problem there. We're just waiting for a final order. Of course, we had marathon hearings of that matter. Navdeep ji explained that at length. And after almost concluding the matter, that matter also went through ups and downs like anything. But the hearing almost concluded, and the judgment was to be reserved. But the bench said, well, we have 1 or 2 questions tomorrow, and we'll ask that. And then it went into a loop and the matter could not be heard. There were other important matters that took up. But now we will probably not need more than just a formal determination by the court, because the point has been covered. The issue was that, stopping litigants or cases which were coming from Armed Forces Tribunal, stopping them or prohibiting them from going to high courts was a big problem to the litigants, and it was against the constitutional bench judgments and the mandate of AFT itself. So I think we've crossed that bridge.
Before we break, I wanted to make one non-commercial announcement. I've just posted on the chat feature word about as a webinar or a Zoom town hall that is going to be sponsored tomorrow morning at the same time, or I guess tomorrow night for you, at the same time, for global military justice reform. We're going to be doing these town hall Zoom meetings the first Monday in every month. And this is the 4th one we're having, and the guest speaker will be Brigadier Retired Anthony Pafidi, who was the Director of Service Prosecutions in the UK, and he's going to be talking about the report prepared by Mr. Justice Sean Lyons for changes in the UK military justice system, and I think it might be worthwhile. And in any event, admission is free, and you're welcome to attend.
Mr. Chitrat, I've just received a private message from Mr. Thomas from Canada. Can I just answer it? It's just a private message. So
no issues.
Yeah.
No, it could have been posted privately, but once the message is now it will become public.
Yes, it is posted privately, but I'll reply in public. You know, we believe in transparency. Mrs. Bhatti fought that privacy case. So, and she said that we believe in transparency. India believes in transparency, so I must answer it in public. So the question is that in the Indian court-martial system, is the court obliged to accept the instructions of the judge advocate on matters of law, or does the judge advocate simply advise? Yes, the judge advocate simply advises. It's not binding.
Okay. We have Advocate Savitri Dhanesha, who is also professor fortuitously. She wanted to express some words of after the session, and we have just unmuted her. Ma'am, yes.
Hello. How are you, sir? This is Savitri Dhanesha, and it has been an immense pleasure. I take an immense pleasure in stating that the program has been great. The idea has been very novel. Probably people like us who do not know anything about AFT, it was purely a knowledge sharing and a thought-provoking session. We have really enjoyed this. Thank you so much. And I hope Beyond Law CLC will come up with more such programs. I really like to thank Mr. Jean FIDELL, AISHWARYA Bhatti ji and NAVDEEP ji. I think the way they have showered us with knowledge, I really thank them from the bottom of my heart. I've really enjoyed the session thoroughly, sir. Thank you so much. Thank you, Vikas ji. Thank you, Vikas ji, for organizing such a program.
As ma'am was saying that we will have sessions. Tomorrow we have a session on right to silence by a senior advocate from Gujarat, Mr. SINGH Pandya, who has also been the president of the Gujarat Bar Association. So stay connected. We have already posted the message that you can connect us through Facebook page or Instagram page for latest updates or our mobile number. Now,
thank you so much. Thank you.
It would be a pleasure that we get the insights from people like you that encourages us to do better. And one message like Navdeep received on the WhatsApp, I've also received one message. They say that Ms. Bhatti is a niece of their very close friend, Professor Bhatti. He's a doctor. I was just reading the name. I've just received the message that kindly convey our feelings. Meanwhile, we have Sujoy Kantawala, who is already just like Navdeep and Aishwarya, who comes quite often on the TV to give his insights. Sujoy's smile shows it all that he has actually thoroughly enjoyed the program. I just wish that we could unmute everybody so that we could have the expressions. But our experience has been. Yeah.
Can I say?
Yeah.
Mr. FIDELL, Major Singh, good friend Aishwarya. I have as articulate and elegant as always, Aishwarya. We have been together on so many TV debates on various social issues. But I'm so glad. Actually, I'm here in the Corona hotspot of India, Mumbai. But I'll tell you, what a fantastic evening and a Sunday evening to spend with all of you all. I mean, this is such an unknown, uncharted territory for most of the councils like me. And now that I know Aishwarya is any matter like this, I have to refer to her immediately. Fantastic. Salute to all of you all. And the way you have explained in such simple language that guys like me and so many other participants who never knew about this niche territory now have become so aware of the fine niceties of this particular field of jurisprudence and law. Thank you so much again from the bottom of my heart.
Very kind of you.
So, thankfully, there are no further questions. And I always say that once there are not many questions, one is that we have already said that we should have somewhere stop. That's good on the part of the participant that they have understood the timeline should be actually followed in stricto sensu. Once we are going globally, let's people carry the image that we don't go by the scheduled time. We are quite thankful before.
Please explain stricto sensu.
Please explain stricto sensu to the layperson. And that you will have to explain this time.
You're the dominus litis.
You will have to explain. And dominus litis, Aishwarya will explain. Yeah. Explain it stricto sensu.
No, it's your explaining it. You are the one who has used it for the layperson.
I think let's just leave it for everybody to decide on their own.
we can have a.
He was pulling your leg because you were making all of us explain those legal terms.
We can have another session on Latin maxims.
Yes, that would be great. A great idea, Navdeep ji. I think
I just noticed one thing. May I just butt in? I just noticed one thing that both of you, Major Singh and Aishwarya, you all were discussing that, and you informed us that so many judgments of the Supreme Court have not been implemented. You know, that is something that is really sad. That Supreme Court judgments, which are final, binding across the length and breadth of India, and so many instances you have given, that is something that we need to have a lot of concern for.
It's very sad. In fact, the political executive, that's the problem, that the political executive want these to be implemented. The Prime Minister has made a statement. The Raksha Mantri has made a statement. The last Raksha Mantri, I mean, late Mr. Manohar Parrikar made a statement. Even Mr. Antony made a statement. So the entire political spectrum wants litigation to decrease. The Attorney General has written, the Solicitor General has written for reducing litigation, but the lower level functionaries are not allowing it to happen. It's very sad.
Navdeep bhai, before we actually part, we can connect besides this platform also. Now you have been connected me to a wonderful person, Aishwarya, and then Professor FIDELL. And one question, Professor FIDELL, some people have just posted, what is the time, Indian Standard Time, or what is your time when this Zoom invite has been given? The invite looks to be quite tempting, so people would like to latch on.
It's 9 a.m., which is to say
9 a.m. would be 6:30.
9 a.m. East Coast U.S. time, and everybody's welcome. While I have the floor, I just want to say this. I commend you for organizing this. It's a privilege to meet you all and to see some familiar faces. I also will say that I hope everyone stays well. We haven't talked about there actually are military legal implications to the pandemic. I'm currently doing some writing on that subject, but most importantly, I hope everybody stays well and continues to take appropriate precautions. And I will also say, while I'm at the store, that if you've been following the news, the United States is going through a particularly terrible patch right now that I'm sure you're all roughly aware of. I haven't tuned in for the last 2 hours, but I'm hoping that today will be a more quiet day than last night and the night before. So, you know, life goes on with new challenges, and I hope that you're able to surmount those that you're facing, and that will be okay as well.
Thank you, Professor FIDELL. Navdeep, many people are asking what is the title of the book and what actually it covers, which you have, I just seen more like a curtain raiser on the Facebook that you had said it's a soft launch. So
the latest book is called Military Pensions, Commentary, Case Law and Provision. So it's like a reference book for, you know, entire issue, the entire gamut of the aspect of pensions, the different types of pensions in layperson terms, not in legal Latin maxims. The book prior to that was called Named by the System. So it was real life stories of people, military veterans, disabled soldiers, etc., who had to fight battles with the system and then legally claim their rights. Because of the pandemic, Amazon is having problems because some of the distributors were in red zones, but it is available directly from the publishers, and you can just go to my personal book website called www.navdeep.info. That contains all information about the books, the subject matter, etc. Navdeep.info.
Can we see the cover of the book? At least I have seen on the Facebook. You have that book in and around?
No, not around me. I'm sitting in my drawing room.
I thought that Amazon is having troubles, but at least we should see the curtain raiser in the right perspective.
Yes.
thank you everyone on behalf of Beyond Law CLC and ULS Punjab University Chandigarh. We are just
And I also want to thank some Mr. Chatrat. There are many decorated officers from all around the globe who have joined us. Special thanks to them, including Colonel Sullivan and General Ghosh, General Sapru, and many Colonel Sharma. Many of them I can see familiar names. Colonel Ajeen Kumar. So thanks to all. Some of them are very gallant officers, and thanks to everyone, especially from the US Marine Corps.
That is quite heartening and encouraging for us also, that people who have actually served for the nation are joining us for the insights, and especially when they know that people who are experts in this field are pitching in their views in the point which could be actually done. As I was saying that we are all enamored with the way you have shown the perspective. I was sharing with Ms. Bhatti and Navdeep that invariably we had always a session and then we had a Q&A. I was just talking to Navdeep prior to the session also that we will be going for a session. It's more an interactive session. This week, we are all mainly with the interactive session, like sports law, we were having with the senior counsel, Puneet Bali and Yuvraj Singh. Then we have live-in relationship, the contemporary law. And that fortuitously, Navdeep and Bhatti ma'am, we can ask them, they will be participant, and one of the key speakers would be Sujay Kantawala and Tanveer Meer. And then we have Raj Khosla, famous director, who has done a lot of ad movies and movies, plus movies also, to have the contemporary law. That's quite challenging. So we are all thankful on behalf of Beyond Law and CLC. And we have Shobhit Fatela, a bright lawyer practicing in the High Court. So I thought his insights, what he has experienced, and a vote of thanks from a young budding lawyer who is doing exceedingly well within the profession. Shobhit, over to you.
Thank you so much, sir, for your kind words. This truly has been a very interesting and a thought-provoking session, sir. I, for one, did not have the complete picture of military laws, and today's webinar was really enriching and has inspired me to look deeper into the issues of law, especially this field of military laws, not only from the perspective of India, but also from the perspective of other jurisdictions. I formally thank the speakers, Mr. Jean FIDELL, Madam AISHWARYA Bhatti, and Major Navdeep Singh for sparing their valuable time in their respective time zones and sharing their rich experiences. It definitely was a learning experience and encouraging for a young lawyer like me. There's a lot to learn and a lot to take back from today's conversation. Mr. Jean FIDELL's views have been very insightful, especially with respect to civilian and military trials. Sir has outlined two areas of law which have been overlooked, and perhaps there is a lot of scope of research in these issues. One being correctional programs for military convicts, and second being professional ethical issues and the need to make policies in this regard. Sir has also emphasized on the need of generally accepted principles which must be adopted, and an effort which must be made by governments all across. Thank you so much, sir, for being a part of the seminar. Madam AISHWARYA Bhatti's contribution towards the development of law has especially been very encouraging. Opportunity for women in permanent commissions in the Indian Army is a pertinent issue. The judgment which has been cited is not only a gender victory, but is also important in bringing men and women to an equal level playing field. As Madam said, battling gender inequality is a battle of mindset. Thank you, ma'am, for being a part of this talk. Major Navdeep Singh has pointed out the flaws of tribunalization. Sir has very well elucidated on the history of tribunalization, from the case of L. Chandra Kumar to Madras Bar Association and the Roger Matthews case. The insights which have been provided by Sir are very nuanced, and there is a lot to take back from the conversation, and definitely a lot to read for all of us, especially all the young lawyers, given that now we've gotten a good perspective about the issues of law involved. Thank you, sir, for being a part of this. At last, I'd like to thank Mr. Chatrat for organizing this seminar. The webinar has rightly been titled as Beyond Law. It's not only about general civil or criminal laws, but also about diverse areas of law which one may not be very well aware of, including me. And these issues assume great importance in our day-to-day life. I thank you, sir, for conducting this, sir. Thank you all.
Thank you. Stay blessed. Stay safe.
Thank you so much.
And let's see the legal maxims, etc. How do they actually shape up? That they, as they say, just a seed which is creeped up in the mind actually turns into a plant and then ultimately becomes a tree which everybody will cherish. So let's see how things actually shape up. Everyone stay safe. Stay blessed.
Can I give you a legal maxim in Latin?
Sure,
Yeah,
please do.
yeah.
I mean, we have
parting
to
shot.
vox populi, vox dei, but the maxim I want to share is the time-honored error communis non fecit lex, which means the fact that everybody's wrong doesn't make it law.
The parting shot is the final shot. Right.
What a wonderful evening. Thank you so much.
Thank you. Thank you.
Thank you. Thank you for a lovely